Good, madam, go.
Madam, can we start or
Hello.
Aradhna ma'am?
Mute.
Mali, just 2 minutes.
No
Just
problem.
waiting for minutes
Okay.
takes, you know.
Okay,
takes.
okay.
Sorry, just 2 minutes.
No problem, madam. No, not.
Himali, we can start now.
Okay, sir. Okay. So we have approximate 200 participants right now with us. So good afternoon, everyone. NISM along with SEBI warmly welcomes all the participants to today's webinar on SEBI Circular outlining the general guidelines for dealing with conflicts of interest of market infrastructure institutions, market intermediaries, and associated persons in the securities market. This circular marks an important step in strengthening governance standard, enhancing transparency, and reinforcing trust in the functioning of securities market. We are truly honored to have with us Ms. Aradhana Verma, General Manager, SEBI from MIRSD team and her entire team as an esteemed expert in securities regulations and market governance. With her deep understanding of regulatory framework and her decade of extensive experience in the financial ecosystem, she is uniquely positioned to help us unpack the intent, significance, and practical implications of SEBI's guidelines. Her insights today will undoubtedly help all to gain clarity on the expectation laid out by SEBI and how organization can effectively align with them. We request you to please share your questions in Q&A session only. With this, I hand over the session to Aradhna ma'am to take it forward. Aradhna ma'am, over to you.
Thank you, Himali. Thank you, Rajuji, for having this webinar on a very relevant subject. And, you know, it's something which is always relevant, conflict of interest. So, good afternoon, everyone, and a warm welcome to all the representatives of the MIIs and market intermediaries who are joining us today for this webinar. We are actually very, very pleased to have you with us for this important session on general guidelines for dealing with conflicts of interest, which has been very kindly organized by NISM. As a securities market regulator, one of our core responsibilities is to uphold the integrity, fairness, and transparency of the marketplace. Conflicts of interest, whether actual, potential, or perceived, pose a significant risk to these foundational principles. In an environment which is as rapidly evolving as now, where products are becoming increasingly complex in nature and investor participation is expanding rapidly, clear and consistent management of conflicts of interest has become more important than ever. Let me emphasize one thing here before we actually take you through our guidelines and have a discussion on that. Conflicts of interest are not inherently improper. They obviously arise naturally in a dynamic ecosystem where intermediaries are performing multiple roles and they interact with diverse client groups. What is critical is how these conflicts are identified, disclosed, and managed so that investor interests remain paramount and market confidence is protected. In today's webinar, I, along with my team, we will guide you through the general guidelines for dealing with conflicts of interest, which was issued by SEBI in August 2013. And we will be touching on the following topics: conflict of interest in the securities market context, proactive identification of situations that may compromise or appear to compromise independent judgment, standards and disclosure expectations which are set by the regulator, best practices for internal controls, record keeping and oversight, and we will also be having a few examples, and maybe as participants you can also quote certain examples to us. So with these words we will start the presentation. Is the screen visible?
Yes, ma'am.
Sonali?
Yes, ma'am. Yes, ma'am.
Yeah, so today the subject matter is general guidelines for dealing with conflicts of interest. What exactly is a conflict of interest? It is a situation where our personal or self-serving interests clash with our professional duties or client market interests. Sometimes these clashes can impair our judgment, objectivity, our independence, and they create a risk of biased decisions. Like, when we know we are going to benefit from something, sometimes we are not able to manage that conflict, and then that results in a conflict of interest. Conflict of interest can be actual, it can be potential, or it can be perceived. So what exactly are these types of conflicts of interest? In normal parlance, I've just quoted some examples, just to make you understand. An actual scenario happening is, for example, an employee uses material non-public information about a company to trade its stock for personal profit before the information is public. So here what has happened, this employee was actually in possession of some UPSI, and he just uses that information for his personal gains. So this is an example of an actual conflict of interest. A example of a perceived conflict of interest is when an employee who's accepting expensive gifts or lavish entertainment from a client, he can create a perceived conflict, as others might assume that the judgment is compromised or they have been bought. It may or may not be true, but it is a perceived bias which will definitely come. Then as an example of a potential conflict of interest, Say, for example, an employee is currently in talks with a competitor about a future job while still working for their current employer, potentially influencing their current decisions, especially concerning confidential information on vendors. That is something which can very much happen in the future. Now, why managing conflict of interest is important for the securities market? Conflicts are inherent in capital market activities across businesses and roles. We cannot have a management of conflict of interest in case-by-case basis, simply for the reason that there are multiple scenarios, multiple intermediaries, multiple decision points. So it is very, very important to have clear structured policies which guide consistent judgment and behavior. Regulators obviously expect defined responsibilities and effective processes to identify, manage, monitor, escalate, and report conflicts. SEBI came out with a circular on general guidelines for dealing with conflicts of interest in August 2013. Now, today we have participants, I believe, from AMCs, from brokerage houses, from portfolio managers. So all of you who are conversant with the SEBI regulations, they know that all the regulations of SEBI which are concerning intermediaries have provisions on conflict of interest. This provision applies across the securities market ecosystem to strengthen governance and investor protection. What was the background for coming out with this? ISCO Principle 8, which came out sometime in 2013, said that the regulator should seek to ensure that conflicts of interest and misalignment of incentives are avoided, eliminated, disclosed, or otherwise managed. So the circular came out basis this ISCO Principle 8, and it provides general guidelines for our exchanges, depositories, clearing corporations, and market intermediaries and their associated persons, with an objective of avoiding, eliminating, disclosing, or otherwise managing conflict to protect investors and market integrity. We have now discussed what is conflict of interest, but just to reiterate, a situation where an entity's or associated person's interests may diverge from the client or market interest, leading to potential bias. Associated person has been defined as a principal or employee of an intermediary or an agent or distributor or other natural person engaged in the securities business, and includes an employee of a foreign portfolio investor or a foreign venture capital investor working in India. So if you see the definition of associated person, it is very wide, practically implying that most of the persons who are associated with an intermediary, they would be expected to adhere to the guidelines of conflict of interest. What are the general requirements? Very briefly, we have touched upon some. The first is establish, document, and implement a conflicts of interest policy with active senior management involvement. The process for identifying and mitigating conflict of interest should be developed in an appropriate manner. Senior management of the intermediary should be engaged fully in all aspects of conflict identification and take a broad view of the risk posed to their business. The second is identifying actual, potential, and perceived conflicts and set procedures to manage and mitigate them. The conflict of interest policy must identify the conflicts arising due to provision of different services by an intermediary and specify procedures to deal with each particular case. The policy should be able to highlight conflicts of interest according to the business structure and activities of the market intermediary. Clearly stated policy and procedures assist in limiting unnecessary use of discretion and communicate to all concerned, that is internal employees, customers, regulators, etc., the intent and procedures of the intermediary. Third is develop an internal code of conduct and standards of appropriate behavior. An internal code of conduct requires employees to disclose potential conflicts, avoid situations where their personal interests could improperly influence their professional judgment, and follow a defined process for managing and resolving conflicts. Communicate the conflict of interest policy to all relevant stakeholders. Communication can be in different forms. Communicating to stakeholders requires a multifaceted approach that is clear, transparent, and consistent, ensuring that the message is understood and acknowledged by all relevant parties. Different stakeholders, for example, employees, board members, vendors, etc., have different needs and levels of understanding. Adapt the communication to the specific context, avoiding technical jargon where possible. Policy should be very, very clear, and communication should be extremely clear so that everyone knows the implications of their potential actions. Implement information barriers or Chinese walls where required. Information barriers are used to mitigate the risk posed by conflicts of interest. Information barriers are used in the forms to block or hinder the flow of information from one department to another. This is important for market intermediaries due to their complex structure. For example, an information barrier could be set up between the research division in an intermediary and the merchant banking division, as the research department could produce a biased report on a company whose underwriting is being done by the intermediary. For information barriers to properly take effect, it is essential that the procedures are clearly defined so that only the concerned divisions have access to any information that is deemed confidential. Educate associates on conflict of interest compliance. Educating associates requires clear communication, regular training, and fostering an ethical workplace culture. The goal should be to ensure that employees prioritize the organization's interest over their personal ones to maintain integrity, transparency, and legal compliance. Maintain high standards of integrity. That is something obviously expected in the marketplace. This would involve adhering to ethical standards and ensuring that personal interests do not compromise professional judgment. It can be accomplished through clear policies, open communication, and implementing specific strategies when a potential conflict arises, such as disclosing the conflict, stepping away from the situation, that is recusal, or having an independent third party oversee the decision. The last two are very similar. The last two are very similar. Ensure fair treatment of the clients and not discriminate. Ensure to give primacy to clients' interest above personal interest. Businesses must ensure that client interests always take precedence over their own personal or commercial interests. Clients should be treated equitably and fairly, regardless of their financial status or background. Special attention and care must be given to vulnerable customers, such as low income, less educated, or older individuals. What are the specific controls and disclosures which must form a part of the policy? Disclose policies and procedures for managing the conflicts to the concerned stakeholders. Provide clear disclosures to clients on possible sources or areas of conflict. So basically, an intermediary should have possible scenarios, possible ways of how to deal with such situations, and ensure that clear communication is made to the persons associated with it. Restrict or prohibit conflicting activities when necessary. That is, avoid, for example, avoiding of incentives that encourage selling products misaligned with the client risk profile. Say for a very senior citizen, you tell him to go and engage in F&O activities. So that would be like, you are giving way to the fact that you can earn more commission maybe if you indulge in such an activity. Impose trading restrictions for relevant persons, but that is while handling an issuer client mandate in that security. Do not deal in securities while in possession of material non-public information. Do not communicate material non-public information while dealing in securities on behalf of others. Implementation and review, how can you do that? Board and senior management of an intermediary or an MII should put in place proper systems to deal with scenarios related to conflict of interest. Provide guidance to identify, eliminate, or manage the conflict situations, and conduct periodic board reviews to assess compliance and effectiveness. Few examples which we wanted to share. Anyway, I think most of you are from the market and possibly you are quite well versed in all these things, but no harm in giving a few examples. Front running is one of the prime examples of conflict of interest. Just see this, where the broker gets an order from a client to buy a certain amount of shares. He places order for the same stock from his own account and then places the client's order. Makes a huge killing on this. So is this correct? No. there should be these situations should be dealt with properly by the intermediary. Research versus corporate finance services. This we had discussed prior also. Merchant banks intermediate the interaction between the issuers and investors in the capital market. Issuers will obviously benefit from overly optimistic research, while the investors, on the other hand, will benefit from unbiased research. If the incentives at the intermediary for the provision of these two services are not properly aligned, employees at one side of the firm will be tempted to distort information to the advantage of the clients and the profit of their own department or business unit within the intermediary. Investment advisors providing distribution services to an advisory client through its associate or family member, taking some trading positions prior to communicating investment advice to clients, providing execution services with embedded fees in terms of kickbacks from partner stockbrokers, using client data for cross-selling other products such as insurance, loans, real estate. So we can see so many scenarios are there where there could be a potential conflict of interest for investment advisors. Would you guys like to speak about research analyst?
The research analyst, like as I already said, one of the major conflict of interest for them is having, like, many research firms may also have merchant banking arm, and if they are doing merchant banking activity for a company, so probably they can issue a favorable research report for them. So that is a major source of conflict of interest for them, as well as the research analyst or the associates may indulge in providing recommendations on social media platform, where while giving that kind of recommendation, they can do front running also. They can also get involved in market manipulation activity to get illegal benefits out of their position. So that is a major conflict of interest scenario which can occur in the case of research analysts also.
Inducements, very, very common across industries. Big source of conflict of interest. They are external to the standard commission or fee for a service. Gifts and inducements can take the form of goods, monies, and other services and can result in the influence or favoritism of a specific client, action, and even non-action in some cases. This is a sample implementation checklist for guidance. An organization should have a conflict of interest policy which is aligned to SEBI guidelines, obviously an organization regulated by SEBI. Identification of associated persons and mapping of potential conflict scenarios by business function, establishment of escalation or approval matrix and appoint a compliance owner, implementation of Chinese walls, segregation of duties and personal trading rules, prepare client-facing disclosure templates and internal conflict register, train staff and run periodic compliance testing. I think this is the bare minimum which should be done by a regulated entity. Over and above, it's always good for good governance. Thank you. And now I think we can take, the presentation is over. We can take some questions.
So we can see under Q&A. So Mr. Pranav, I think so I would request NISM to go ahead with this Q&A. I mean, they should start this. Is it visible on the screen? Yeah. NISM, are
Yes,
you audible?
yeah, Abhishek is audible, yes.
So, questions where can we see from Q&A only, na? The link is just next to share.
Yes, sir. Yes, sir.
Okay.
And there are few questions in chat as well.
If we can see.
Yeah, we'll see. We'll see.
Okay, we can see.
Let's start with the chat.
Chat recognition.
Chat.
I request everyone to please put the question answers in Q&A session so that panelists will not have to juggle.
We are like, okay, there is a question regarding certificate of webinar completion. I think NISM can answer to this.
There is no certificate provided for this webinar. While sending the invitation, we have already written in that this is just a knowledge sharing session and there will be no certificate issued for this.
There is a demand for the presentation copy, so we will share with NISM. NISM can circulate with the participants.
Okay, sir.
Okay, then. Okay. Yeah, I think we can see multiple requests for presentation copies, so we will be sharing it with NISM.
Okay, so there's a question.
There's a question from Mr. Ujwal. How to manage conflicts between holding company and its subsidiary which are doing similar business, however client base is different.
So here, Mr. Ujwal, I would just like to say that, you have to, in your own wisdom and given by whatever is happening around you, you need to have clear policies in place, first of all, to identify, what kind of situations would lead to conflict of interest. Like, where, say, for example, I'm just, saying something like a promoter of a holding company giving a loan to, the subsidiary. A lot of things are not allowed. But if somebody does something like that, that would, whether it is under the law or not, whether it comes under LODR or whether it goes over and beyond, that is something you will have to identify. And, you should have those scenarios clearly documented where there could be potential situations of conflict of interest. And that is how you would be handling it.
Next is do's and don'ts, like some of them we have discussed in the presentation. However, all of you are aware that the regulations which are governing the intermediaries, they have respective regulations, also have the provisions. So that must be looked into and followed.
Yeah, and in fact, somebody has written that do's and don'ts nice to get updated. So I would just say this is a very old guideline of 2013. So been more than 12 years, and I am very sure that whichever intermediary is present today, they all have this policy in place. And it's from our side, it's just a regulatory perspective of what are the expectations. But I'm sure most of you are aware of what to do and what not to do.
Mr. Rishabh has a question. What would be strictly followed between investment advisory, equity research, investment banking? See, the high-level principles are narrated in the presentation as covered under the SEBI circular. Apart from that, even specific instances and specific restrictions have already been, like specific compliances for avoiding conflict of interest and dealing with it, are already present in the circulars governing the intermediaries and also under the regulations. So that must be followed. I mean, whether it is a research regulation, research analyst regulation, or investment advisor regulations, both have these kind of provisions. Similar for in merchant banking also.
So Tanvi has asked, do we have to change our existing policy according to the measures discussed? Tanvi, this is a broad overview of the circular. And if you are already following the circular, you really don't need to change anything. We have not really told you exactly how to frame your policy. We have given you broad pointers, and that same thing you will find in the circular as well. And then how you make your policy is up to you.
Yeah, however, it is required that the principles which are stated in the circular that are adhered.
That should be adhered.
So now we are,
We'll
I think,
move to Q&A.
Yeah, we'll move to Q&A now. You can see some questions over here. There's a question from Mr. Pranav. For example, let's say a company is dealing in PMS and plans to start a new strategy which invests its client's fund in its group company's mutual fund. Will this be considered as conflict of interest? If yes, what procedures the PMS should be doing in this scenario? Okay. So basically, PMS service, the client who is availing the service of the PMS, it is the basically objective is the work of the duty of the PMS provider that the best interest of the client is served. So, but if you are referring the client a mutual fund, so there can be a hidden interest that you want to, the PMS provider wants to earn, out of that investment in terms of the cost and all, which may not, however, the PMS provider has to see that the investment in a particular fund should be to the best interest of the client. So that is the, basically the basic acid test here, which must be followed. So if something is in the interest of the client, and however, to avoid any kind of perceived conflict of interest, it is advisable that PMS should try to avoid recommending the funds which are managed by its associate. So next is, sharing a presentation. We have already discussed. SEBI or MFI, will SEBI or MFI or industry body provide a conflict of interest procedures?
So as we already said that, the broad guidelines are already in place, which are basically the principles on which you have to frame your conflict of interest policy. So you are free to make it as you want, depending on the type of intermediary you are. Maybe you may be a broker, you may be an MC, and there are different guidelines which have been prescribed by SEBI or AMFI or the exchanges. But the broad principles which are there in the circular should definitely form a part of your conflict of interest policy.
What is the penalty levied if an AMC takes a client of a MFD? So the question is not clear. So more details can be, it can be.
We are not able to understand the question.
I think conflict of interest can't be avoided completely. They can be reduced. Yeah, that is true. That is true.
That is true. It cannot be avoided. It is there in all the situations in our dealings in the market, but we should be able to identify and mitigate to the extent possible.
What checks to consider for determining conflicts on client aspect?
What checks to consider for determining conflicts from
client aspects? So basically, it seems that you are asking from the investor's perspective. So an investor who is availing some service from an intermediary. So if the intermediary is referring, suppose, or doing some cross-selling or referring some other related entity, associate company for availing some other service. So there can be a potential of conflict of interest. The client should be aware of such scenarios and try to get more information to ascertain whether it is the actually the case.
This question we have already answered by Rushabh.
Yeah, Mr. Rushabh, this question was answered while, it was in chat also. So, okay, this question from Mr. Ankit Ranjan. I would like to ask that does conflict of interest has any certain structure or can it be anything depending on behavioral psychology varying from person to person? So I think
this is a very broad question, and I will give an equally broad answer. And that is that conflict of interest cannot have a certain structure. It could be of different types. And those scenarios are something which some scenarios we already know. Like, for example, I can favor a client, I can take a gift from the client and do something more for the client being a part of an organization. That would be kind of a, conflict of interest. So there could be front running, there could be insider trading. So many scenarios are there. So these are scenarios we are aware of. As we evolve, there could be newer scenarios. So structure, as per se, there is no structure, but we know the principles. And when we know the principles, our job is to have a policy around it so that everyone is aware of how to mitigate the risk. which can emanate from this kind of conflict.
Will there be any NISM certification on compliance with conflict of interest? NISM may like to answer. Yeah, Raju ji from NISM, Hemali.
Yes, sir.
Is there any NISM certification on compliance with this conflict of interest?
Conflict of interest, sir, there is no certificate from NISM.
Yeah, but however, NISM has been organizing this kind of sessions. I mean, so obviously that will be of the help.
Sir.
But there is no certification as such.
No, sir.
So for PMS there is certification, but as such for conflict of interest there is no certification.
But that might be covered in some of your certifications
Yes,
relevant for
the topic may be covered in the certificate of the
certifications applicable for different intermediaries. Yeah, it would be there.
yes, sir. For specifically for conflict of interest, it can happen in mutual fund, it can happen in PMS, it can happen in AIF. So as such, we are not covered on that single topic, but in a broader scale, it's been covered on the topic itself, sir.
We hope that answers the question. So this is the same question, Mr. Pranav. I think we have dealt while going through the chat. Close relative of employee and directors would be included in the conflict of interest policy. So it is already included. Like for example, we discussed the case of passing of UPSI. So if an employee passes the UPSI to its close relative, that is definitely a conflict of interest scenario. Does front running involves buy, sell, or also buy also classifies as front running when we buy for client also and for us? Yes, buy also qualifies.
As long as your trading is influenced by the client's trading and for your own benefit, any scenario will get covered.
You can sell today, you can sell later.
Yeah.
As stockbroker, I can apply PMS application under same company. So basically, this doesn't pertain to the topic.
To the topic at all.
Can we have a list of policies to avoid conflict of interest? See, broad level policies are like this, as we discussed these are in the circular regulations and circulars relevant to your, category of intermediary is already there. We are a stockbroker IA, Mr. Radhakrishnan. We are a stockbroker IA and RA. Do we need to have separate policy or we can have combined?
If you are three separate entities, three of you should have a separate policy.
Because the regulations can have some peculiar provisions.
Yeah.
Depending on the nature of services. So that must be looked into. Okay. How to open our on AMC? It's not relevant to the topic. Question from Mr. Bajaj.
This again is not relevant to the
Anonymous
topic.
attendee,
No,
again, MTF share questions not relevant. Okay. So same questions are repeated.
What if an employee?
There is a question from anonymous attendee. What if an employee buy equity in a particular company and after that he gets ordered to buy shares? So basically you are saying that front running is by accident. It's not by design.
Yeah.
See, anywhere, there is a conflict of interest has to be avoided, even if it is potential, it is actual, or it is perceived. So.
And I think in this particular scenario, he will, once he gets an order to buy shares, he will need to disclose.
Disclosure is required.
Yeah.
Such cases. Like for a research analyst, if research analyst recommends certain scripts, certain securities to his clients, he has to disclose if he has any association with the company. If he has any holdings, his positions also he has to disclose so that the investor can take an informed decision. So that would be required. Similar arrangement would be required in this case also. Same question, how to open AMC doesn't pertain to the topic. So
none of these questions has been
same question has been repeated. AMC questions we are getting multiple times. Okay. So basically, Please organize more webinars whenever any new circulars are published.
Sure, feedback has been taken. We will try to have more webinars on relevant topics.
Can you just define associate person, whom to be included or excluded? So as we discussed, there's a SEBI CAPSM regulation. So in that regulation, there's a definition of term associated person. There you can get, more information about that. However, briefly, we have tried to touch upon the definition during the presentation also. So basically, it's a principal or even an employee
Distributor.
of an
agent.
intermediary, an agent also of an intermediary involved working in securities market. So basically, it's very broad and seems to cover everybody who is into the carrying out core activities of the intermediary.
Yeah.
Okay.
Same questions.
More webinars when new SEBI websites, SEBI circulars are published. Okay. Same. Is trade overlap between investment decisions of different vertical seniors conflict?
It could be if it is something which both the different verticals are aware of. In that case, it could be seen as a trade overlap and could be seen as a conflict.
How to open on AMC? The same questions multiple times.
So you may approach our IMD.
For for the questions which is coming up again and again regarding the requirements for opening an AMC. So there's other department of SEBI, IMD, Investment Management Department. So
Please
the
get
person may approach to them. Yeah.
Pradeep Padmanabhan, if I'm an individual who wants to be certified RA as well as upgrade to it be considered.
As of currently we have it is permitted to have both the licenses. However, there has to be clear segregation. Even clients are to be different, and apart from that, there should be a Chinese wall kind of segregation
Yes.
between these two activities. So now I think we are. As a stockbroker, can he apply PMS license under same company?
This again is unrelated to the topic, and you can approach the PMS department or the stockbroking department for further clarification.
Please share question. So we request not to flood the Q&A with same questions again and again.
Does changing liquidation strategies without informing the client create a conflict between client interest and the broker's operational convenience?
Actually, anything what has been communicated already to client, if there is any deviation from that,
Same has to be informed.
if one entity has two licenses, a stockbroker and RA, then we should have two different conflict of interest or one will do. As we already discussed in this response to similar question, different regulations may have their peculiar requirements. So there should be two separate set of policies. It may be similar, however, there can be differences as well.
Privacy gets disclosed, but then you have bought the shares. This is by the anonymous attendee. I think it's a follow-on reply he has given, where he has written, but while disclosing that what I bought to employer, my privacy gets disclosed after getting buy order from employer. That time, I think it was buy order from a client, right? So I'm assuming it is a client you're talking about. But then that is a good practice and good governance, and that is integrity. That if you have bought and your client gives a buy order for the same securities and you are disclosing, that is good governance. That is something which is expected behavior under the terms of conflict of interest policy.
Yeah, as we already discussed, conflict of interest would be best avoided, and if not avoided, it should be disclosed. MTF position before the regulatory trigger point.
The client's interest should be primary for you. Just to answer this question on conflict of interest for a broker, to liquidate MTF positions before the regulatory trigger point, if doing so benefits the broker but harms the client. But as a stockbroker, your client's interest is a primary responsibility for you as well. So if we go by that construct, then in that case, it would definitely be a conflict of interest to liquidate MTF position before the regulatory trigger point.
I think we have come to end of the questions. Evidence of Chinese walls is enough to prove addressing of conflict. The question is not clear. From Mr. Sankar, Prabha Sankar. I mean, from evidence of Chinese walls is enough to prove addressing of conflicts, not clear. The next is Yogya Kalra, does we buying on individual level and also for the client classified under front running, and if we can do such buying, what measures to be taken care of to avoid conflict of interest. As we discussed before, the client order, self order should not be executed.
Yeah.
So it should be avoided. Herein holder has not kept nominee. How to get his held? It's okay. This is also unrelated from anonymous attendee.
Yeah.
It's regarding nominee.
So I think we have come to the end of the questions. Just to conclude from my side, I would like to say that our objective here at SEBI is to support the market participants in strengthening your compliance framework, enhancing your governance standards, and promoting a culture where transparent handling of conflicts is not viewed as a formality, but as a critical pillar of investor protection. I would like to thank all of you for taking the time to join us today and for your ongoing commitment to maintain the highest standards of professionalism in the securities market. Thank you from SEBI's side.
Thank you. Thank you. Thank you, everyone.
Thank you all for your active participation in today's webinar on SEBI's circular outlining the general guidelines for dealing with conflicts of interest of MIIs and associated persons in the securities market. We hope this session has provided clarity on the intent behind the guidelines and has helped you better understanding the governance, expectations, and compliance responsibility that lie ahead. A special note of gratitude to Ms. Aradhna Verma for her insightful session. Her deep expertise and practical perspective have truly enriched today's discussion and given us valuable takeaways to implement within our respective organization. Thank you once again for joining, and we look forward to meeting you in our future sessions. Have a great day.
Thank you so much. Thank you, Himali. Thank you, Rajuji. Thank you, Kuldeep.
Thank you, Abhishek sir.
Thank you, everyone.
Aradhana ji, thank you very much for completing
Thank you,
this
sir.
program.